Hello guys, welcome to Current Affairs Prelims Crash Course 2023, lecture number 5 worksheet. Hope you have seen the worksheet. Now we have started the section of polity. The topics covered are acts, amendments and rules. From here lot many questions are coming because new legislations are being tabled in the parliament and certain amendments are being done into the existing laws. So guys, the current affairs prelims course, you are already watching the course. In the 40 hours of limited time, the majority and most important section of the current affairs will be completed, from which you may get questions from 25 to 30 directly in the examination. Let's see question number 1. Consider the following statements with reference to new guidelines to banks on Foreign Contribution Regulation Act Rules class, FCRA. About FCRA, I have talked in detail into the class. It was enacted in 1976. It requires every person or NGO wishing to receive foreign donation should be registered under this act. It was amended again in 2010. Certain new regulations have been provided by the Ministry of Home Affairs. Okay, Ministry of Home Affairs, not Ministry of Finance. You should remember this. Recently, what amendment has been done, class, that it allows now Indians to receive rupees 10 lakhs per annum from relatives who are living abroad. Earlier, the limit was 1 lakh. So it has been increased. Therefore, it was in the news. Moreover, if the limit has crossed, it has become more than rupees 10 lakhs, then what happens? Government gives you certain time to inform. Now the time is about 3 months. Earlier it was 1 month. So it has become more liberal. Let's see the question statements. It is mandatory for all NGOs to receive foreign funds in a designated bank account at the Reserve Bank of India's New Delhi branch. First of all, remember, Reserve Bank of India does not take any money from citizens directly. Rather, it is mandatory for all NGOs to receive fund in the designated branch of SBI, State Bank of India, New Delhi. You remember this. Therefore, the statement is wrong. Statement number 2, foreign contributions can now be received through banking channels or in cash, not in cash. You know, we have done an exercise called as demonetization. The reason was to have more of an inclusive and bank-based system. Okay, we are getting rid of cash-based economy slowly and steadily. Therefore, it has to be received through banking channels. Statement 2 is also wrong. Which of the following statements is are correct? The correct answer is D, neither 1 nor 2. One more point I would like to tell regarding FCRA class. Now the compoundable offences has also increased to 12. Earlier it was 7. Compoundable offences are the offences where the complainant enter into a compromise. You know, if person A is complainant and A has complained against B, then A can enter into compromise with B and agrees to have the charges dropped against the accused. A has agreed to drop certain charges against the B. Therefore, these compoundable offences have increased from 7 to 12 right now under the FCRA. Let's move to question number 2. With reference to Criminal Procedure Identification Act 2022, consider the following statements. Yes, class, this is important because this act has replaced the previous identification of Prisoner Act 1920. Okay, now it provides legal sanction to the police to take physical and biological samples of the convicts as well as those who have accused of any crime. Physical as well as biological samples. Focus on this point. Got it? Yes, biological samples are very important. UPSC might ask you what are the biological samples. It is something like finger impression, iris or retina scan or signature, even blood samples, hair. Okay, and records has to be stored for 75 years. Now, let's see the statements. Rules made under this act apply only to the prisoners arrested for offences that involve imprisonment of at least 1 year. Class, the biological samples has to be collected from the prisoners who are convicted of the crime against women or children, or they have committed certain offense whose punishment is at least 7 years. Then only their biological samples will be collected, not 1 year. So statement 1 is wrong. This act mandates the storage of convicts' record for period of at least 75 years from the time of collection. Very true. Under this act, the National Crime Records Bureau is designated to create a database both at state and at national level. Class, NCRB maintains the data only and only at national level. At the state level, each state is required to notify an appropriate agency to collect and preserve the database. The state government will notify. Got it? State government will notify certain agency, appropriate agency to collect and preserve this database. NCRB only at national level. So the statement is also wrong. Which of the statements above is are not correct? I understand students sometimes we miss out on this. This is very important for our prelims. Reading this statement also is important. Which of the given statements is are not correct? Therefore, 1 and 3 should be the correct answer, B. And about the records, if I talk about the records need to be destroyed in case any person who has not been previously convicted of an offense and is released without trial or discharge. Person has been released without trial. In that case, the records need to be destroyed also before 75 years. Got it? Question number 3. Regarding the legal provisions related to phone tapping, okay, phone tapping, consider the following statements. It is regulated by the Information Technology Act 2000. We hear this act so many times in the news. Therefore, we might fall for the statement to be correct. But the statement is wrong because which law is governing the phone tapping? Indian Telegraphy Act 1885. Okay. In India, only central government has power to tap phones and state governments are prohibited from doing so. No class. Section 5 clause 2 of this Indian Telegraphy Act gives power to both center state governments to tap the phones. Therefore, state governments also have the power. The statement is wrong. This statement is also wrong. Correct answer should be correct answer statement has been asked. The correct answer should be D. Neither one nor two. Question number 4. Consider the following statement with respect to general network access, often heard in the news. Class, what is general network access? Recently, what has happened? Central Electricity Regulatory Commission (CERC) has issued certain guidelines related to general network access. Okay, under the current system, what we are having right now, the power generator, the power stations, the power generator has to work out how the electricity will be wheeled out to the consumer, how it will reach the consumer electricity. Okay. Now, under the GNA, General Network Access Regime, what we are planning, okay, it will enable the supply to the consumer from any point, any state. Okay, the basic aim is to provide non-discriminatory open access to interstate transmission system. Got it? Let's read the statements. GNA is a non-discriminatory access to the intrastate transmission system for an estimated maximum injection and for a consumer to draw for a specified period. Okay, so class, intrastate, it should be interstate. I get your point. Some of you might think if it is interstate, it's a bigger subset. Intrastate should also be correct. But the objective, the larger objective of GNA is not to connect to the intrastate. Its objective is to connect to the interstate. So the statement is wrong. For a maximum injection, yes, because so many power generators will be connected throughout the line, and for a consumer to draw for a specified period. They can take the power from the lines for a specified period. These other half statement correct, half statement wrong. This is also a style of giving statement by the UPSC. Statement number 2, GNA is beneficial for both the generator as well as the end consumer. This is a correct statement. Correct answer should be B. Question number 5. With reference to the Medical Termination of Pregnancy Act, MTP Act 2021, consider the following statements. Only the selected state and UTs will constitute a medical board that includes 4 members in total. Class, no. It is not the case, we know. Not the only selected states and UTs will be there. Okay? It is like you should understand that every state government or union territory, as the case may be, notified by the official gazette, constitute a board. Okay, and it will have, yes, 4 members. This statement is true. A gynecologist, a pediatrician, a radiologist, or a sonologist, or any other member specified by the gazette will be included in the 4 members board, but not the selected states. So statement 1 is wrong. The pregnancy can be terminated after 20 weeks if the child is suffering from only a mental disability. This makes the statement wrong. Only a mental disability. Even if physical disability is there. Okay? Mental or physical disability. The name of the woman who has terminated her pregnancy can be disclosed by the doctors. No registered medical practitioner can disclose the name of the women who has terminated her pregnancy. Statement is wrong. The punishment for the violation of laws is 2 years in jail and a fine or both. It's 1 year's class. I have discussed the provisions in details in the class. So, which of the given below statements are incorrect? All of them are incorrect. Question number 6. Consider the following statements regarding carotar. Okay, class, about carotar, basically, it's a custom administration of rules of origin under Trade Agreement Rules 2020. Okay, customs, related to customs. Set of, it is basically, you should try to understand, for example, this is China, this is India. India is giving certain concessions, okay, under the tariff. Now, what is happening? It is about rules of origin. China is rerouting its goods via Vietnam. Okay, therefore rules of origin should be specifically mentioned. This is how carotar will deal. It is notified by the Ministry of Finance, not Ministry of Commerce. Under this, basically, there is need to ensure that important goods meet prescribed rules of origin provision for availing concessional rate of customs duty under any free trade agreement. Got it? Earlier, what used to happen? Merely a country of origin. We used to say country of origin certificate issued by any notified agency in the country that was exporting. That was sufficient to avail the benefits. Now, the carotar will be followed. The set of guidelines for, let's read the statements. The set of guidelines for enforcement of the rules of origin for allowing preferential rate on imports under the free trade agreements. Correct statement. They replace the existing operational certification procedures prescribed under the different trade agreements. Class, they do not replace, rather they supplement. Okay, so statement is wrong. Correct answer is A only. Question number 7. Which of the following is are the objectives of scientific social responsibility? Okay, recently Department of Science and Technology has released SSR Guidelines 2022. These guidelines are related to the creation of knowledge ecosystem for sharing ideas and resources, infusing scientific temper into day-to-day lives of ordinary citizens. Now, third point is to nurture 10,000 technology startups in software product industry. As this is the objective of national policy on software products 2019. Here the objectives of two different schemes seems to be mixed. Therefore, third statement is wrong. Okay? Correct answer should be 1 and 2 only. Got it? Question number 8. Consider the following statements regarding NDPS Act 1985. Narcotic Drugs and Psychotropic Substances Act 1985. Basically, class, this act prohibits a person from, production, manufacturing, cultivation, possession, purchasing, transportation, consumption of any narcotic drugs or psychotropic substances. So therefore, it actually bans these kinds of uses. Now let's read the statement. Statement number 1, all the offences under the NDPS Act are non-bailable. This seems to be an extreme statement, but it is really true. Under the Act, property acquired by a person from drug-related offences who has been convicted under the Act can be seized, frozen and forfeited by the government. बिल्कुल सही बात है, ऐसा होना भी चाहिए. True. Which of the above statements not correct? Therefore, both of them are correct actually. Therefore, correct answer should be D. Neither of them are not correct. Question number 9. Consider the following statements regarding internet shutdowns. It's too much in the news. Recently, it has happened in J&K as well. Okay. What has happened? It has evolved. In the class, I have discussed in detail how the freedom of speech has been linked with the internet. Therefore, Supreme Court judgment under Article 21, sorry, Article 19, Clause 1A. It seems to be confusing with Article 21, but it is freedom of speech and expression. Okay, Article 19, Clause 1A of the Constitution, it has been declared as a fundamental right. This statement is absolutely true. Statement number 2, Section 69A of the Information Technology Act 2008 gives the government power to block particular websites and not the internet as a whole. Yes, class. Even under Section Dhara 144, Section 144 of CRPC, that says that in an unavoidable circumstance, the order can be issued by an officer of the at least joint secretary level, okay, authorized by union or state home secretary. That person can only authorize for the shutdown of particular websites and not the internet as a whole. Therefore, the statement is also right. Which of the above statements not correct? Both of them are correct. Therefore, correct answer should be D. Okay, guys, keep watching our lectures and keep practicing the sheets. You can join our offline course at Delhi, Bengaluru, and Pune centers and can complete your prelims crash course of current affairs in a hassle-free manner. Thank you.